everybody. Welcome to this session of the CSA Research Summit 2023. The topic of this session is understanding the AI Act and its relationship with the GDPR. So the overall goal of this session is to give you a high-level overview of the upcoming AI Act, the main obligations that it contains, linking the AI Act to the GDPR, and then analyzing what impact the AI Act may have on cloud service providers, particularly those who have already put in some work to achieve GDPR compliance. My name is Martin Tabarda Barata. I'm a partner at ICT Legal Consulting, and I'm joined today by my colleague, Isabella Oldani, senior associate at the same firm. So the table of contents that we have for you today is as follows. We're going to start with a brief introduction to basically set the table for the rest of the presentation. Then we have a section dedicated to the AI Act, where we'll cover some key definitions necessary to understand the AI Act and its provisions. And we will go over the AI Act's risk-based approach. The point of this is to help you understand what sort of AI systems are impacted by the AI Act, which depends essentially on the degree of risk which is assigned to the system by the classification mechanism within the AI Act. Finally, we will have a small survey, a list of 4 questions which cloud service providers can ask themselves in order to make a fair estimation of whether the AI Act will apply to them, depending, of course, on the use of AI systems that each cloud service provider employs. Then we'll move over to the GDPR for those who are not familiar with the GDPR. We will cover definitions within the GDPR, key definitions necessary to understand the GDPR's provisions, and we'll touch upon the scope of application of the GDPR. This is with the goal of understanding where there is an overlap between these 2 regulations, which is the core part of this presentation and will be dealt at the end. The idea of this part is to explain what are the points of possible inconsistency between these 2 regulations, the points of contact between these 2 regulations, and overall, what should a GDPR compliant cloud service provider be aware of when looking to leverage its GDPR compliance to achieve AI Act compliance. Finally, we'll try to share some core practical considerations as conclusions for cloud service providers who may need to bear the AI Act in mind. One overall caveat, which we'll go over just in a second, is that this presentation is based on the current wording of the AI Act. It's not yet finalized. We have considered the original European Commission proposal and the latest amendments approved by the European Parliament, but the document is subject to further change before its final publication and entry into force. So be sure to stay updated with AI Act developments as they come out. With that said, I will leave the floor to my colleague Isabella to take us through the first part of the presentation. So Isabella, go for it.
Thank you, Martin. So as mentioned, the scope of this session is to go through the main provisions of the AI Act and of the GDPR to understand to what extent these 2 pieces of legislation overlap and interact with each other. And we will also try to give some guidance to cloud service providers to understand to what extent they are captured or not under the scope of the AI Act. So as mentioned also before by Martin, the AI Act, so the text of the AI regulation that we're going to look at today is not the final text because the AI regulation is still undergoing the legislative process. However, we did have the chance to review the latest version, which was approved by the European Parliament, and the legislative process is expected to end by the end of this year, 2023, and then the AI regulation should become applicable starting from 2025. So, as mentioned, the text of the AI regulation that we're going to look at today is not the final version of this of the text, because the AI Act is still undergoing the legislative process. The version which we had the chance to look at it for the purposes of this presentation is the one which was recently adopted by the European Parliament this summer, and the legislative process is expected to end by the end of this year, 2023, and then the AI regulation is expected to become applicable starting from 2025. So just to give an overview of the scope of the AI regulation, this has been being developed for the purpose of boosting the development of AI systems, but at the same time safeguarding some crucial principles, which of course should be protected in the process. For example, the protection of fundamental rights, more broadly, the protection of health, but also the democracy and environment. So overall, the purpose of this regulation is to, boost development while still safeguarding some fundamental rights and other essential principles, basically. So this slide shows some of the definitions which are set out under the AI regulation. So starting from the definition of AI system, this is defined as machine-based systems that are designed to operate with varying levels of autonomy and that can, for explicit or implicit objectives, generate outputs such as predictions, recommendations, or decisions that influence physical or virtual environments. Then, from a subjective point of view, the AI regulation identifies several actors, and depending on the qualification, they would undertake different types of obligations, and they would be subject to different types of requirements. So the two main actors which are identified under the AI regulation are the providers of AI systems on the one hand and deployers of AI systems on the other. So providers of AI systems are those natural legal persons, but also public authorities, agencies, and other bodies that develop AI systems, while deployers are those parties which are using those AI systems. So providers are those which develop the system, and deployers are the actual users of the system. As we will see later on in the presentation, the core of the obligations are placed by the AI regulation on providers. However, there are some obligations which are also imposed on deployers. Lastly, affected persons are also defined under the AI regulation as natural persons or group of persons that are subject to or otherwise affected by AI systems. Of course, there are more definitions, but these are useful for, understanding also the rest of the presentation. So moving to the next slide. So it is important to understand firstly that the AI Act is not meant to regulate every type of AI systems, regardless of the type of risks that they generate. But the AI Act is actually based on this categorization that you can see on the slide. In particular, we have 4 levels of risk, which may arise from the use of AI-based systems. So we have some risks which are defined identified by the AI regulation as unacceptable risks. Then we have high risks, and then we have limited or minimal risks. And depending on the type of risk, the obligations and generally the requirements set out under the AI regulation are different, as we can see in the next slide. The AI regulation has set out different requirements depending on the systems. In particular, the systems which are considered to raise excessive risks, so basically risks that are considered unacceptable, as we have seen before, are prohibited under the AI regulation. So they are bundled together, and this is, for example, the case of social scoring by public administrators, but also remote biometric identification in real time in publicly accessible areas. So these type of risks of systems are deemed to be too risky and therefore prohibited under the AI regulation. Then we have some other type of other systems which generate high risks. And in this case, since the risk is still considered, let's say, acceptable, but still it is high. So this is why the AI regulation sets out some specific obligations and requirements. This is, for example, the case of credit risk scoring, but also some activities which are carried out in the workplace, for example, the screening of CVs in the context of recruiting activities, for example. And then we have low or limited risk systems, which are subject to less stringent obligations because and mainly these obligations are in terms of transparency, so ensuring that end users are aware of the fact that they are interacting with the AI-based systems, for example, the use of chatbots and AI-enabled video games. Okay, so in this slide and also in the following ones, we will have an overview of the main obligations which the AI Act imposes on providers and also on the deployers. So as mentioned initially, the core of the obligations set out under the AI regulation are imposed on providers. Here on this slide, we have some, we have an overview of some of these obligations, which are in terms of technical requirements, security requirements, but also the obligation to register their systems in a EU database, and also the importance of ensuring a human oversight over the functioning of these AI systems, which are deemed to generate high risks. And this will also be useful for the following, for one of the points that we will cover in the rest of the presentation. It's also important to note that providers are also required, are also subject to several transparency requirements towards deployers, meaning that essentially providers are required to inform deployers and make them aware of the overall functioning of the AI systems, in particular the intended purpose of the system, the technical documentation which has been developed in relation to the system, what are the limitations as well of the AI system that a given deployer intends to use. So generally speaking, there are several transparency obligations that the providers have towards deployers, so that deployers can make an informed use of these of the intended AI system. Deployers as well, as mentioned, are subject to some of these obligations, some of the obligations set out under the AI regulation. Again, some of these obligations are around the technical and organizational measures. Again, implement human oversight, ensuring that appropriate security measures, cybersecurity measures are in place and monitored. And it is also worth mentioning that we have seen before that the providers are supposed to inform and share with deployers several information on how AI systems, on the functioning of AI systems, and under the AI regulation, deployers should use this information that was received by providers for the purpose of developing the data protection impact assessment as required and where required by the GDPR. So basically, the obligation, the transparency obligation that that the AI Act imposes on providers can then be used by deployers when they are acting as controllers under the GDPR to develop this DPIA. And then another interesting obligation, which is set out under the AI Act, is the obligation to carry out what is called the Fundamental Rights Impact Assessment, which is in fact an assessment that has to be performed by deployers in order to assess the what risks would arise from a given AI system in light of the intended use of that system, in light of the categories of individuals or groups of individuals which are most likely to be affected by the use of this AI system. And also, as a result of this assessment, deployers should also identify appropriate measures to ensure that the identified risks are appropriately mitigated. Okay, so this slide is just is meant to give an overview of the fact that there are, besides what we have seen, like the overview of the obligations that we have seen on deployers and providers, there are also some additional specific obligations which are imposed on specific AI systems, depending on the case. So, for example, in the latest version that we have, the text of the AI regulation, the text which was approved recently by the European Parliament. So there are some additional obligations are imposed on providers of foundation models, which are also defined under the AI Act. And in particular in relation to generative AI systems, which are based on these foundation models. And the most common example would be ChatGPT, for example. They are required under this new text to disclose that content was generated through AI, and they are also required to implement some safeguards against the generation of illegal content. So basically, there are several sets of obligations depending on the type of AI system, essentially. Then in the this slide is meant to guide cloud service providers through the types of questions that they should ask themselves in order to understand whether they are captured or not under the scope of the AI regulation. So the first question that they will need to ask is whether they are engaging in activities which are covered by the AI Act. So whether they are carrying out any activity that would be captured under the scope of the AI regulation. In particular, Article 2 of the AI regulation provides that the regulation applies to providers placing on the market or putting into service AI systems in the Union, regardless of the fact that they may be established outside the Union. It also applies to deployers of AI systems that have their place of establishment or that are located in the European Union. And it also applies to providers and deployers that are located or established outside the European Union, but when the output of the product is meant to be used in the European Union. So this is the first set of questions that say to be asked to understand whether a cloud service provider is captured under the scope of the AI Act. If the answer to this first set is yes, so it's positive, then they should determine whether they qualify as a provider or as a deployer, because as we have seen above or before, the obligations vary depending on the qualification of the actor. So of course, if they are qualifying as providers, they would be subject to a set of obligations, and if they are acting as deployers for the purposes of the AI regulation, they would be subject to a different types of obligations and consequently of responsibilities as well. Then even if the answer to this second question is yes, so it's positive, as a third step, they will need to understand whether some exceptions apply. So the AI regulation provides for some exceptions under which the provisions of the AI Act will not be triggered. That's, for example, the case of AI systems that are used as safety components, or AI systems which are used exclusively for military purposes. And then if the answer to this question is no, so meaning that none of these exceptions will be triggered, then another point of attention would be to understand whether the AI system in question falls under the temporal scope of the AI Act, because and this is relevant because pursuant to the AI regulation, only AI systems which are developed after the date of application of the AI Act will be captured by the scope of the AI regulation. However, it is also possible that AI systems which have been placed on the market or put into service before the date of application of the AI regulation may still be captured under the scope of the AI regulation if they undergo substantive changes after the date of application of the AI regulation. Okay, so now we'll move to the overview of the scope of the GDPR, and I'll leave the floor to my colleague, Martin.
Thanks, Isabella. So we have here a brief recap of the main definitions within the GDPR for those who are not familiar with the GDPR or have forgotten. There's 5 key definitions that should be understood in order to follow along with the rest of this presentation. Very first is the definition of personal data. Very simply put, any information that can be connected to an identified individual is personal data. So easy examples are normal identifiers like a name or an identification number or date of birth or an email address. But essentially any information that can be traced back to an individual can be considered personal data. This includes information which has been pseudonymized or encrypted, provided that this process is reversible. A data subject is an individual to whom personal data relates. So if you have personal data, you have at least one data subject to whom that information relates. Processing refers to any operation which is performed on personal data. So collecting personal data is processing personal data, storing it is processing it, disclosing it to third parties is processing it, and even anonymizing or deleting personal data is a form of processing personal data. Then the other two definitions relate to the type of role that an organization can take regarding a given processing activity. If an organization is deciding why a processing activity should be performed and the essential elements of the means for that processing activity, so for example, deciding the types of personal data which will be processed, deciding the types of data subjects from whom data will be collected, deciding how long the data will be stored, or deciding who the data will be made available to, that organization will normally be acting as a data controller. That means that the organization has a larger degree of responsibility regarding the processing activity because the processing activity is carried out primarily under that organization's instructions and for a purpose defined by that organization. Conversely, if an organization is acting as an outsourcer for a controller, essentially executing processing activities under the instructions of a controller and for a purpose that the controller decides, then that organization will normally be qualified as a data processor. In the cloud service domain, cloud service providers are often qualified as processors on behalf of their cloud customers if they have a cloud service which processes personal data. Although this isn't always black and white, there may be some activities for which a cloud service provider should be seen as a processor, but other activities, such as, for example, using personal data in the connection with analytics activities for its own service improvement purposes, for which a CSP can more accurately be qualified as a controller. In our experience, normally a CSP is a mixture of both. The GDPR is meant to update the rules on personal data processing within Europe. So, I mean, since 2016, it's been doing this. It applies directly in the member states of the European Union or European Economic Area, and therefore applies to all organizations handling personal data which are established within the European Union or Economic Area. However, it also applies to organizations which are outside of the European Union or Economic Area if they target individuals within Europe. So, for example, if an organization which is located in the US provides goods and services directly to consumers within Europe, they are subject to the GDPR. And the same applies to third country organizations which monitor the behavior of individuals within Europe. Having said this, some of you may have already detected that there's an overlap between these two regulations. So one situation where both of these regulations will apply to a single organization. And this is where an organization is using an AI system which is considered high risk under the AI Act and which processes personal data under the GDPR. So if you have an AI system which handles information on individuals, you may be subject to obligations under these two regulations. Now, having said this, it's important to understand that there are some inconsistencies. We put this in quotation marks because it's not clear that these are incompatibilities, but certain types of inconsistencies between these two regulations. So, for example, we've discussed that the AI Act, its core obligations fall upon providers. Providers will typically be seen as data processors under the GDPR because typically a provider will be creating or putting into the market an AI system which will then be used by a deployer for a purpose that the deployer will define. So much like a software as a service would function, the cloud service provider will put the service on the market and then it's cloud customers who will use that service for the purposes that they see fit. Conversely, the GDPR, its main obligations fall upon data controllers, with only limited obligations being applied to processors. Deployers under the AI Act will typically be controllers under the GDPR. So the users of AI systems will typically be controllers under the GDPR. So we see that there's a different focus, whereas the AI Act will normally focus on providers / processors under the GDPR will normally focus on controllers / deployers under the AI Act. Both regulations also use similar or identical terms, but which correspond to different concepts. One example is transparency. So transparency under the GDPR refers specifically to the obligation that data controllers have to explain to data subjects how their personal data is processed. So data controllers have transparency obligations, which refer to providing clear and understandable information to individuals about the terms under which the data is processed and what rights individuals have under data protection legislation. In the AI Act, transparency requirements apply between providers and deployers. So providers have transparency obligations towards deployers in terms of facilitating documentation to ensure traceability and explainability of the AI systems and their operations, providing documentation and user manuals that will allow deployers to then comply with their own obligations. And deployers may have some transparency requirements towards affected persons or the ultimate end users of AI systems, such as explaining the rights that individuals have against the use of AI systems with respect to them. And for example, making it clear that individuals are interacting with AI systems in specific cases, like the case of a chatbot. There are also points of contact between these two regulations. For example, because deployers have to receive information from providers on AI systems, this information can be used by deployers, for example, to execute a data protection impact assessment over an AI system which processes personal data, and also to share information on how the AI system works with data subjects. Because these two obligations are requirements under the GDPR, the fact that providers are required to provide this information to deployers under the AI Act is beneficial for deployers' GDPR compliance regarding AI systems. Secondly, a deployer which has invested in GDPR compliance should already have some sort of methodology for executing data protection impact assessments. This methodology can potentially be expanded to function as a fundamental rights impact assessment methodology, because under European legislation, data protection is just one fundamental right. So in theory, you can take the existing DPI methodology that you have and just expand its scope to cover other fundamental rights, not necessarily overlapping with data protection. Finally, the GDPR establishes not an explicit but an implicit requirement for producers of applications, services, or products that are used to process personal data to bear data protection by design considerations in mind. This means that these producers should be creating these applications, services, or products with the idea that they will not create any technical obstacles to data protection compliance and will in fact facilitate data protection compliance for their ultimate users from a design stage. So something that should be considered from the outset. The AI Act's obligations upon providers sort of mirror this with respect to the obligations under the AI Act. So providers are required to develop and document their systems with AI Act compliance in mind. And this is ultimately leading providers as well to consider data protection considerations, seeing as deployers will not be able to lawfully engage or use AI systems which fall afoul of data protection considerations. With this overlap in mind, there are three practical conclusions that we can derive from this presentation, and which hopefully should help guide cloud service providers that rely on AI systems currently. The first is that if you use or develop AI systems, you should make sure that you have all of these systems mapped to make an initial determination of whether the AI Act may apply to any of the systems that you use or develop or market. If so, then you'll be able to also make an initial determination of whether those systems are high risk or not, or prohibited, being that prohibited, high risk, and other specific types of systems like generative AI, foundational models, and so on, are subject to requirements under the AI Act. If you have any such systems, then you should make sure that you have or otherwise develop adequate documentation concerning those systems, which you can provide to your deployers. This means documenting the functioning of those systems, the terms under which they process, what input they process, how it's processed, and what output they're meant to provide. If personal data is involved, to what extent is personal data processed by the AI system, and essentially providing instructions and user manuals for deployers to make sure that the AI system is properly understood and used by deployers. Finally, it's important to bear in mind that GDPR compliance is not enough to ensure AI Act compliance if you leverage or market high-risk AI systems which process personal data. However, if you are GDPR compliant, then you can benefit from those compliance activities and leverage them to facilitate your routes to AI Act compliance. For example, the fact that you have a record of processing activities which describes how your AI system processes personal data, or that you have a data protection impact assessment which analyzes the potential impact upon individuals that the processing activities inherent to your AI system has. These can help comply with transparency requirements within the AI Act. It can help comply with assessment requirements under the AI Act, because the AI Act also requires the execution of DPIAs or fundamental rights impact assessments. And overall, it can help making sure that your AI system can be lawfully marketed and used by deployers within the European Union in compliance with this new AI Act. Of course, it is, though, important to keep track of the AI Act as it develops. We expect the legislative process to end by the end of this year, which means that by the end of this year, we will have a final version. But we do not expect very material or substantial changes to that which we have presented in this presentation. I have a list of references that we used for this presentation available on screen. Namely, the first two links link you to the current texts for the AI Act and, of course, the published text of the General Data Protection Regulation. And that's it for our session. So thank you very much for your attention and time. And we hope we have been useful to cloud service providers currently leveraging or seeking to leverage AI systems.